Hi guys, it's Kathy. I hope you're doing well. Tina, I don't know if you're still there. Hi Tina. OJ time. Oof. Oh, I get so excited. I get so excited when I press play for OJ because how far down we are. The list of videos. Like, I had to keep scrolling to get here. And then, if I want to get to the end of the list, it's just done. That's so cool. I can't believe we did this. We're crazy. We are crazy for doing this. We just are.
Did you ever use the word defect?
I'm not sure.
You might have, right?
I could have.
That's what you came down here to look at the gloves for, to see if you could find a defect,
I've used
correct?
that word before. Just saying. I
wanted to see if there was any marking in a specific part of the glove that corresponded to a shadow on one of the videos. I wasn't sure whether it was lighting, whether it was a mark. Just wanted to look at it.
To see if there was a defect on the evidence gloves that corresponded to what you saw in the picture.
Correct.
Wasn't there, was it? There was no such defect on the evidence gloves, was there?
I didn't see anything
This
that I
whole
could
trial
definitely
was a
re-identify
defect.
in any photo.
Defect.
Now, which picture were you looking at where you thought you saw shadow, defect, or whatever you want to call it?
I don't think that picture was actually used here. It was one of the photos that was thrown out. It was a right hand.
You referring to one of the gloves the prosecution decided not to use?
I believe that in an effort to save time, they just started to arbitrarily knock out different photographers and photos.
So the one where you thought you saw a defect, they didn't show to the jury.
Sustained. Sustained.
All right. Now, you've indicated from many of these pictures that it's your opinion that you can identify the 3 points on the back as being the same type of 3 points that is on the ARIS 70263, correct?
That's correct.
Now, you've indicated that's a common backing, correct?
It's very common, yes.
Are there other backings that can be mistaken for that?
I'm not quite clear as to what you mean by that.
Well, let me show you a sheet. So we would take a look at that.
Do you have some foundational questions on this?
Yes. You recognize that as a document that shows various different kinds of stitching that can be used on gloves.
Yes, I do.
Are you familiar with all of those?
I recognize many of them.
You know, can I have that mark and put on the envelope, please?
Need a little more foundation than that.
Are all those, there's different kinds of backing stitching, correct? The 3 points we're talking about.
Yes. These are different configurations of what I would call 3 decorative points on the back of the glove.
And you recognize all of those, do you not?
I actually don't recognize all of these.
Okay. So there may be some out there that even though you have a lot of experience with gloves that you're not familiar with.
There's many that are out there, but not necessarily used.
My question was,
Could be.
that some out there that you don't know.
Could be.
And the top part of that diagram indicates different kinds of stitching for fingers, right?
They do, but they're poorly represented in these sketches.
Okay, but you recognize each one of those? I mean, they're described underneath them, are they not?
Yes.
They're all stitches you're familiar with?
I'm familiar with all of these.
May I have that mark put on the envelope, please?
That's 1373. Mrs. Robertson, 1373.
Can you see those sample stitching, because those are the silkings that we've been talking about.
Right.
The 3 points on the back. Which of those, if it's up there, is on the ERA 70263?
These sketches are actually so poor and not really indicative of what they say compared to what's on a glove. If you want me to pull out a glove to show you, like as an example, the bottom right, it says 4 needle stitching. If you want me to pull out a glove and show you what 4 needle stitching looks like, it doesn't look like this. I can't tell. I can't tell from this.
You can't tell from those stitches which one is on the ERAs?
The way the draw machine works, there are 5 positions, there's 5 needles. You can configure them to do things in different formats. What's on the back of 70263 is needle number 1, 2, and 3 with thread, without cord. I don't know where it is on here. It's a blur.
Now, could I put 612B on the hour, please?
Yes.
Mr. Rubin, you recall identifying this picture, this is the Gadara picture,
Yes.
and identifying the backing on the glove?
Yes, I did.
Can we back it out a little clearer, please? Your testimony that you can tell that backing was made with a particular configuration of 3 needles?
It appears to have a ridge in the middle. The reason I came up with that is it appears to have a ridge or a high-low in the middle of each point, and that's what gave me indication that it was 3 needles. There has to be a needle on the right, a needle on the left, and because it has a ridge look, I think there's a needle in the middle, and that's what gave me that conclusion.
You see that as 2 lower lines and a ridge in the middle?
Objection, Your Honor. You didn't look at it on the Alamo.
Well, is there,
You have to remember, I've had the opportunity to look under this photo with a magnifying glass.
Mr. Rubin, we're talking about these pictures that the prosecution offered. Are you telling me from that picture you can see 3 lines of stitching?
Objection, Your
From
Honor.
this picture, I can't see anything.
How about from the picture itself?
From this picture, I see a ridge in the middle of the point, which indicates the 3rd needle.
And just so we're clear, you're saying that in that picture, or all you're saying, that you can identify for each of those 3 lines in the backing that each line has 3 needle stitches in it.
Left, right, and center, yes.
Now, is that something you can see in that picture?
In my opinion, I can see it.
Do you accept how other experts might differ with that?
Objection, that's argument.
Sustained.
Now, in one of these pictures, in the Renkin pictures from '91, you identified water spots on the gloves?
That's correct.
There are no corresponding water spots on the evidence gloves that correspond to the water spots on those gloves, correct?
I'd have to relook at it again, but I don't think that I could even make any judgment regarding to those particular water spots as to how they relate to a glove today.
Well, all right. I asked you yesterday, did I not, that if you got water spots on a glove like that, they might stay there, right?
For a brief period of time.
Did you say brief period of time?
Yes, I said to you that as the gloves were worn again and stretched out, they would dissipate.
You didn't tell me that sometimes they would stay?
To refresh your memory, Mr. Blazier, I also pointed out that if someone with these Aris Lights gloves, which are truly naked leather, were to wipe their brow and get oil on their finger, the oil would stay on the glove for a brief period of time. But gradually, as the person wore the gloves or moved their hands back and forth, the oil would dissipate.
You didn't tell me that water spots like that, you told me that they might dissipate, but they also might stay there, didn't you?
I don't remember saying that.
Now, could we have frame 4748? I'm sorry. I think I may be giving you the wrong number. 4582, I'm sorry.
Mr. Harris, do you need Mr. Fairlow's assistance on finding that?
Well, they're not in the order.
Mr. Ormond, let's take this down until we find the right frame. Thank you.
Yes.
All right.
Remember looking at this frame before, Mr. Rubin?
Yes, I do.
Now, I believe on your direct testimony, you testified that from this picture, you can identify the brosser stitching on the fingers. Am I correct in that?
I don't believe I would have used this one for the brosser stitching.
Okay. But you would use this one for the 3 lines on the back?
I believe this one was used for the palm vent on the left hand.
Okay.
Was the primary purpose.
Now, would you agree that the picture on the monitor is a lot better than the big screen?
Surely better from here, but not as good as the monitor in the back.
Do you see, looking at the monitor, what appears to be a bulge in the palm of Mr. Simpson's left hand under the glove?
I don't detect the bulge.
You cannot see a raised area, what appears to be a raised area right in the palm between the thumb and the fingers.
There's a shadowy effect. It could be slightly raised. I don't know. I really don't know what it means.
Do you know what a heat pack is?
Yes, I'm very familiar with it.
And people use heat packs to put in the palms of their gloves to keep their hands warm, don't they?
I'm familiar with it.
And that's going to cause the glove to stretch, isn't it?
It could. I'm not familiar with what size heat pack we're talking about.
Okay. You can take that down, please. I take it, Mr. Rubin, you would agree that you can exclude the gloves in the West pictures as being the evidence gloves in this case.
Due to the color, yes.
And you can exclude the Romano gloves, correct?
They appear to be black also.
And you can exclude the Kruger pictures, can you not?
Same thing, yes.
Now, I think your testimony was that you can read writing on whatever this is in the photograph?
You can answer the question.
I clearly stated that I could not read the writing on that tag.
All right. But you can see printing on it?
I can see that there is something on it. It appears to be printing. The tag, what I stated is in the shape of the Aris Ross Patch label tag. It appears to be beige in color. It appears to have some kind of burgundy printing on it, which is the same as what was used on all Aris tags.
Now, looking at the Gadara picture again, can you see it from there? You indicated on direct, did you not, that you thought you could identify the brosser stitching on the fingers in that picture, did you not?
On the left hand, on the top ridge of the finger, is a very fine ridge, and that would be the only spot that I could detect it from that glove.
Can you come and show me where you're pointing, or where you're indicating?
Is that the index finger?
Forefinger.
Forefinger?
Do we have one of your arrows? May I put a sticker on it? I'll put it right above here. You're talking about the first finger, where you see a ridge that you can identify as the brosser stitch?
At the end of the finger, there's a very fine ridge, fine line, which appears to be similar to a brosser stitch.
Well,
And that's why I'm saying it's a brosser stitch.
okay, so from my arrow, we're actually looking at the end of the finger itself?
No.
Sugar. Guys, we saw
But I
this.
mean, yeah, the end of the finger.
I'm thousand percent sure we saw this. I'm going to fast forward it to where we...
That's 22.
Show the tag shown in the photographs taken by Mr. Romano.
Yep, we're here.
Done a comparison between
This
the
is where we're
eyeglass
at.
envelope and the paper and the test
Took me
impressions, and that the jeans can be included as
15
having
minutes to
made the
figure out we
impressions
saw
on those
that.
items, that the shirt can be included as having made the impressions on Ronald Goldman's jeans. Your Honor, just to address the last issue of the question of, I don't know whether the court wants me to say anything further about the prosecution's right to conduct tests, even destructive tests, because I don't think it's really all that pertinent. This is not a destructive test, and even if it were, we could still conduct it. And even if we destroyed exculpatory evidence, the only remedy would be for the court to look at that retrospectively, in other words, after it had been done, and then impose a sanction. But I think the court recognizes, or at least did recognize, that prospectively, the judicial branch does not get involved in deciding what tests and what experiments the prosecution can conduct. But I don't know whether the court needs to, or wants to hear anything further on that issue.
Oh, I just wanted to know what it was we had here and where you're going with it.
Okay. As to notice, Your Honor, I said to Mr. Scheck, first of all, when I spoke to him, if you guys want to see the jeans, you're welcome to them. We'll arrange that. We'll be accommodating to you as we have in the past. You want to take your own impressions? Have at it. Have fun. Take impressions if you want to take impressions, and that is our position now. As for the issue
I
of
think
notice...
that includes the shirt as well.
Yes, sure. Your Honor, as to the issue of notice, what I said to Mr. Scheck on that score is that Mr. Diedrich is going to come into Los Angeles. I believe he is going to be arriving here tomorrow in the late afternoon or early evening, so he may not have time to go to the Los Angeles Police Department. But as Ms. Clark has indicated, it is our intention to put this evidence on very rapidly. And we are trying to get everything done rapidly, and we are trying to turn over discovery very rapidly so that we may do this. And we could have done this a lot faster if we had had the discovery,
Have
which
you
we don't have.
received the exemplars back from the FBI yet?
No,
Do you have any of them left? You indicated there were 6 impressions from the Levi's.
but they're all on a single piece of paper, and that was sent to the FBI. And similarly, there's a single piece of paper containing the impressions from the shirt, which was also sent to the FBI. Your Honor, on the question of notice, I said to counsel we would give notice, but I did not want to. I did not want to hold anything up because I want Mr. Diedrich to take these impressions as quickly as possible from the jeans so that he can testify. For some reason, my suspicion is that counsel wants to make what I would think to be an entirely inappropriate and frivolous argument that the manner in which the impressions themselves were taken is a substantive issue as to the admissibility of those impressions. I think it's frivolous because we take impressions all the time of all kinds of things. We have to do that whenever we're talking about a comparative type of analysis or impression evidence. But if they wanted to make an issue of that, I would like Mr. Diedrich to have taken the impressions himself so that he can answer all questions and be cross-examined and examined as to how they were taken. Actually, I don't think that legally that is necessary. But if that is the direction in which counsel is prepared to go, and I suspect it is, as frivolous as it may be, we want to be in a position to meet it, and we can meet it best by having Mr. Diedrich take the impressions himself. And also, it cuts down on the number of witnesses. It saves time. It cuts down on the amount of direct and cross-examination.
Well, if Mr. Diedrich comes into town tomorrow, which is the 13th, late in the day, is not available to examine the items until early on the 14th, then you probably won't be available to testify till late on the 14th, correct?
Ms. Clark tells me that he may be coming in earlier, in which case, if he comes in at any time prior to 5 o'clock, it is our intention to have him go to the Los Angeles Police Department, if necessary, directly from the airport, in order to be able to accomplish this. So that is the people's position. In terms of the defense saying that they need more time to deal with this, well, you know, this is a very tiny part of Dr. Lee's testimony, really. When he testified that he excluded these items of having made the impressions, it only took about a minute for him to say that. I did not cross-examine him at all on that for tactical reasons. And we are putting this evidence on to rebut a minute of testimony that we could have been in a better position to confront had counsel given us notice. They knew they were going to put this on. So I just do not see any basis whatsoever for them asking more time to confront testimony that the people did not have an adequate opportunity to be able to fully prepare for, and where we have been doing everything that we possibly can to be able to confront this testimony, or to respond to this testimony as expeditiously as possible.
All right, any brief response, Mr. Scheck?
Your Honor, just so that the court completely understands the facts, is that, as Mr. Goldberg is now conceding, we do not have these imprints from the pants and the shirt. I should note that from the discovery pages, labeled DA 5365 and 5366. On 5365, they say that, with respect to the jeans, that one sample was taken from the right knee area of the jeans, the other impression was taken from the left lower rear area of the jeans. He made the impressions by taking the yellow pad and applying it to the jeans, etc. So on the August 21st they indicate 2 impressions from the jeans, and then the report says they took 5 samples, impressions from Goldman's jeans on August 31st. So I count 7 from their reports. That's where I come up with it. They gave us 1 unusable picture that you see. Now, what we need to do, as I indicated, is to evaluate what they're proposing to put on, is take a look at the actual sheets of test impressions and compare that to the envelope, et cetera, and the jeans and the impressions from the shirt to the jeans, so our experts can have an opportunity to look at that. In terms of the timing of this, I think what I proposed is reasonable, because we're going to have to get copies of what they don't have here to give us, and send that out. Now, it's going to be adding even more time, and it's totally unnecessary to have Mr. Diedrich make another test impression just for the purposes of him testifying alone. They concede the single purpose of it. And then we would have to take that test impression and send that out to our experts and have them look at it, and it would only prolong the process, not shorten it, in terms of getting an adequate opportunity to evaluate what he's saying. So we don't have adequate discovery to deal with this. I would point out, incidentally, that Dr. Lee turned over all experiments and raw data that were a predicate before his testimony. I don't want to get into that issue. Mr. Blazer briefed it. We've dealt with it. That's not the point. I'm glad that I don't understand, he calls it experiments. He doesn't like the term experiments. He doesn't like the word test. He only likes the word test impression. Call it test impression. The photograph that the court has from A21 shows that it alters the genes. Now, I want to see the genes myself. We want our experts to look at the genes. We want to determine for ourselves whether or not that altered the areas that Dr. Lee testified about. As for this absolutely extraordinary argument that this court has no power to prospectively restrict the unreasonable alteration of exculpatory evidence, and that you're powerless to restrict them from doing that, even though you've already issued an order saying they have to come before you and give you 48 hours notice. I mean, this is remarkable that they can actually take the position, and it's the position they've been taking all along, that we have a right to discourage...
Do you have anything new?
I don't need to tell you that.
All right.
But I would ask the court to permit us to proceed in the fashion that I've outlined. I think that what that will do is give us an opportunity to present the issues to the court for a ruling on the substantial similarity of these experiments. Mr. Goldberg, even though he's talking about what we do, my information is that nobody's ever heard of what Mr. Diedrich is doing before, and I'd be real curious to see if he's ever done imprints made in blood with 2 different fabrics on these receiving surfaces in the fashion that he's done in this case. I suspect he's never done this before.
All right, but we're talking about a pattern impression here of a fabric. So this is not exactly rocket science.
Whoa, whoa, whoa. We're talking about imprints in blood, fabric on fabric, jeans onto shirt, and then jeans onto envelopes. We've just got to see what he's done. But it's imprints in blood.
Thank you, counsel.
Your Honor,
All right.
I should let the court know Mr. Diedrich will be in tomorrow. He should be arriving in this court building by about 11:30. And what we can do is...
Will he have with him the impressions?
He will.
All right.
I'd also propose this, that they have Mr. Diedrich do the impressions, meet in court, and then they can have their expert here to examine everything Mr. Diedrich has done, question him about it, and then everybody can be ready to proceed on Thursday.
All right, thank you.
Your Honor, Mr. Morton, I called him and asked when he would be available. He's got a court appearance. He won't be available till Thursday. He's canceling another court appearance so he could get here Thursday. And they told me he'd be here tomorrow afternoon. And
All right.
we object. We want a ruling that he not be allowed to make any other impressions until we see all these objects and have an opportunity to brief the Griffin question. And from the
Well, the Griffin question's already been raised, counsel.
No, I mean, we want to look, as I'm indicating, I don't know what the genes look like. I can't adequately present this to him.
All right, thank you, counsel. All right, the prosecution is ordered to make available for inspection by the defense and their experts, if such be available, the test impressions currently in the possession of Mr. Diedrich. That's to be accomplished no later than, assuming airplane connections, no later than noon tomorrow. The issue of fabric impressions was raised by the defense. The court notes that both sides have had access to both the jeans and the shirt. Either side had the opportunity any time that they have wanted since June of 1994 to take any impressions in whatever manner they want. The defense had prior opportunity to look at these items. It's apparent from Dr. Lee's testimony that he did, in fact, examine carefully the fabric patterns of both these items. Defense experts have had access to it. I find no discovery violation. The objections are overruled.
We need time if they're going to deliver these test impressions to us tomorrow, I have no expert to look at them. I have to take I have to make copies of them in a way that is usable for the experts. I have to send them out, and I don't believe I'll be able to cross-examine this witness until Monday.
Well,
or
counsel,
present
the issue was
arguments.
raised by your witness. So your witness has already seen impressions, knows about these
No,
imprints?
no. Never saw an impression.
Yes.
He never saw the test. I want an opportunity to look at their test impressions and their results.
You can have the opportunity to look at it, counsel. I've directed that. All right, that's the end of that issue.
To a sitting juror. And the motion that I bring before Your Honor is to have that juror excused because of the conversations that took place on the record
get
in
rid
this
of a
case with
juror.
that juror. And although we have great empathy with the court as trying to do everything humanly possible to make the conditions for this jury tolerable, livable, and in a way that this jury can eventually hear all the evidence and reach a verdict, we are compelled under the law to bring to the court's attention what we believe was a violation clearly of the constitutional rights to an independent and fair jury of our client, Mr. Simpson. And we believe that the court, although noble in its desire and purpose to try to alleviate any potential financial hardship that this particular juror has suffered, has in fact created a legal condition that now has put this juror in a special place. And what
What action has the court taken that puts this juror in a special place at this point?
well, the court indicated action. The court has taken no action whatsoever. But
The court said to the juror, give me a couple of days to look into this.
That's right. But the court also indicated, I believe, that there would be some effort made on the part of the court that would, in fact, result in a financial hardship of this juror being relieved. And since that financial hardship has been discussed amongst other members of the jury by this juror, we feel now that that juror, just from the conversations with Your Honor and from Your Honor's indication that the court would be willing to look into financial aid as well as other support from the court regarding a rental income property, that has now affected this juror in a way that it might cause other jurors to feel that they are entitled to similar types of consideration, to similar types of compensation. The court has not made any ruling whatsoever, nor has the court done anything yet. However, I think it was clear to that juror, who was very comfortable at the end of the conversation, that this court, as it always has towards jurors, was going to do everything possible to try to alleviate that hardship. And we believe just in doing that, this juror now may feel a special kinship to Your Honor.
Well, I've done this for a number of jurors. I have gone out of my way to make sure jurors have been transported out of state to attend families' funerals and gone out of the way and spent county funds to do that. Juror 247 the other day had a problem that we had to deal with. The court made special efforts to do that. Are you suggesting that every juror for whom this court has made efforts, special efforts, unique to that juror, that those jurors should be excused? If you're
No.
making that motion,
No, I am not.
because your position is inconsistent with the court's treatment of all the other jurors.
No, and we commend the court, and in many instances joined with the court, and acknowledge that those things were justified. What this case and this issue, we believe, is different because this involves substantial proposed financial compensation retroactive for several months, not something protracted, something that may come up in the future, something of an emergency, or something that would come up just once. This is something that involves a financial issue, which we believe is separate and distinct from the other very personal issues that the court has shown great empathy for, and properly so, to the jury. And we have always concurred with that.
I seem to recollect, Mr. Shapiro, that when one of the jurors was excused and you chose to take a writ to the Court of Appeal, that you urged that this court should go to a higher level of vigilance in keeping each and every member of this jury intact and on this jury. And you took the position that it's not just reasonable cause regarding excusing jurors, that I should take a heightened level of scrutiny to each one of these decisions. So I think this is an inconsistent position with your prior position.
That is absolutely correct, but we believe in this case that by separating one juror based on financial considerations, that it violates the basic tenets of the United States Constitution and the Constitution of this great state, and gives unequal compensation financially in a significant way to one juror as opposed to 12 others and 2 alternates. And I am sure that all of these jurors have tremendous hardships that would greatly be alleviated with the largesse of this court and by any type of compensation. But we believe constitutionally that that violates Mr. Simpson's rights to have a fair and impartial jury where each juror is treated as one and the same. And this gives the impression, whether it is right or wrong, but it gives the appearance that special treatment is being given to a juror. And we are not saying that Your Honor has singled out this juror for special treatment. This juror came to Your Honor. This juror demonstrated financial hardship, and this juror was apparently in a condition where this juror could no longer continue on this jury because of the great financial hardship this juror was suffering based on some rental income property. And the court sought to alleviate that problem. It is our position, however, that such relief, however wonderful and compassionate, however noble, that's right, that's a better word, however noble the court's desire was, it is not a constitutional right that this court enjoys.
All right, I take it you'll file your motion.
Yes, Your Honor, we have also, just for the record, we have filed a motion, and the other thing that it does, Your Honor, is it puts a juror in a position where the juror now might feel that if this continues, and if the court is going to compensate a juror for lack of income in a rental property, that this juror may have an added interest in prolonging any type of...
Ms. Clark, that's not necessary.
Ms. Clark apparently has a funny bone that has been touched. That this juror might have a financial incentive for wanting to prolong any type of deliberations. Now, we don't believe realistically that any juror wants to do anything other than end this and end this quickly. But we pointed that out in a footnote, and I think it's important to add.
All right. Thank you, counsel.
Your Honor, and we'd like to get an answer as soon as possible so that we can take a writ on this matter. We feel it's that important a constitutional issue.
Well, we may have somebody come forth from the public and volunteer to leave this problem outside of the court. Who knows? It may go away.
Thank you very much, Your Honor, for your
You're
consideration.
welcome, Mr. Shapiro.
Appreciate it.
As always.
Thank you.
All right.
Probably the last issue for today, Your Honor, may deal with the scope of rebuttal regarding certain lay witnesses and where we're going in this case.
We did have the June 17th issue still open.
Yes, we'll perhaps we can pick it up tomorrow. But what I'm concerned about, Your Honor, is Ms. Clark indicated today that the people might rest on Thursday. If that be the case, we'd like to know which other witnesses they have pared down. You had directed Messrs. Douglas and I think Fairlow, instead of Mr. Darden, to get together. They have taken Steve Jensen, Stuart Roper, and Leonid Rubin off of their list. But we still have a list that would be roughly 56 people, less the few who've been called. We need to know who they're going to call in order to get down to this, to finish this case by Thursday. We'd be entitled to those listed names. We'd like to have those now. There may be another issue regarding the 617 events and an issue regarding Dr. Dutton. I guess that'll be coming up next week. So I'd like to have that at this point because if they paired other people down, if they're not calling other people, we need to know now so we can be ready to get this case over with. We want to resume our case. We have witnesses who are out of state, and one in particular we're going to be asking the court probably either tomorrow afternoon or Thursday morning to help us bring back, and a new witness to bring out here. So we want to do that as soon as possible, so there's no delay for next week. So may we have that, Your Honor, some indication of what are the witnesses they paired off, who's coming up next, who will be their witnesses to finish the case. If by Thursday, that's within 3 days, and we're entitled to it.
Mm-hmm. All right, I assume that they are going to offer at this point, a modified Paratus video, that they're going to offer Mr. Diedrich as the fabric impression. Is that correct, Ms. Clark? All right.
It'll be easy to hear from them, Your Honor.
No, just, those are the issues we just finished discussing, so those are pretty obvious, wouldn't you say?
Yes, they are. And I'm trying to get, okay, yes, we knew about those, Your Honor.
Okay.
Trying to find who else they have.
And we are concluded with the glove people. So what does that leave us, Ms. Clark?
Leaves us with Lovaziak. We have to litigate the Bronco fiber issue.
Mhm.
That's, I indicate to the court that would be just very brief. That's admitted that the Bronco fiber witnesses are 3 in number, 15 minutes each. We asking the court, also the Ackers, Lawrence and Nancy Ackerd, Christian Anders, George Field, Don Thompson. Christian Scott, and that gives you another half to go.
That's about 3 days' worth.
Oh, but obviously, then it's clear they're not going to finish on Thursday. That's a pipe dream. How can we finish on Thursday with this number of witnesses? Bodziak, that's preposterous. And I haven't heard Popovich or anything.
No, it's not preposterous, it's optimistic.
Well, it's more than optimistic. I'm optimistic, Your Honor. That's preposterous. Your Honor, the issue is, you know, I think we should be realistic, because that brings me to the last motion I'd like to at least have the court think about. I told you earlier this morning that I think on behalf of the defense, on behalf of Mr. Simpson, we herewith ask this court to modify the sequestration of this jury. The court will recall that approximately, I guess now, 10 days ago, we met in chambers regarding a jury who shall remain nameless, and the court made a representation based upon what we told Your Honor, that you expected this case to be to the jury by the middle of September, on or about September 15th. We're not going to make September 15th, clearly. We'll be lucky to finish this case next week, unless there's some paring down. And so I think that it's unfair. I think that from a standpoint of all of our credibilities, during voir dire, we told this jury they'd get the case in April, as I recall. And so it seems to me that we've reached a point where this jury should no longer be made to suffer. Our client has had to suffer, and we hope to alleviate this situation very soon. But these jurors have been brought in from the outside, and it seems to me the court should seek to modify the sequestration. And this court is very, very innovative when it wants to be, and it seems to me this would be an appropriate time to set up some kind of procedure where these jurors can go home at night and meet someplace in the morning. It's unfair to keep them here, it seems to me, past what we've told this one man. We're going to lose some jurors, as you're aware. And the people at first, we thought they might have understood this. But then when we see this list, and they say, well, this is just 3 days, they still don't understand it. We're going to be well into next week, and the problem is going to be as we've indicated. And so I make this motion most seriously. You can still have the ramifications of sequestration, and you'll recall that before, during picking this jury, you told these jurors not to watch television, not to do certain things, and by and large, they comply with your orders. These people have been here like almost 9 months, and I think they would do that. I think they would welcome it. It would take a lot of pressure off them. If we can finish this case, we still should finish it as soon as possible. But it would be a lot fairer for these people if the court would consider doing that. And we've thought about this. All of the defense agrees this would be an appropriate thing for us to do. Otherwise, we do not, on the defense, want a mistrial, and we're going to move in that direction. If we don't, the court has to spend every few moments apologizing. And I don't think you'd like to do that. You made a nice joke yesterday. Nobody laughed. You look vaguely familiar. I didn't say, no, think back, nobody laughed. There may have been a couple of polite snickers, but nobody laughed. And I'm just saying,
I
Your Honor,
got 3 smiles from the regulars.
well, Your Honor, smile, Your Honor, well, that's a far cry from the laughter that you used to get. You admit that also. So I'm just saying, Your Honor, it seems to be it's time to do something about it. We've thought about it, and we'd ask Your Honor to consider doing that. We would also like, if this is 3 days witnesses, that means it's going to be Wednesday, Thursday, Friday. Then we need to know the other witnesses. Also, with regard to these witnesses, we need offers of proof with regard to who these witnesses are, what they're going to be testifying about. And Don Thompson's already testified, for instance. He's the officer who handcuffed Mr. Simpson within 30 seconds of his arrival back on his property. He's already been called. So we need to know who they are and what they're going to be saying as soon as possible to keep from delaying further, Your Honor.
All right, why don't you have Mr. Douglas consult with Mr. Darden, get the offers of proof as to the names that Ms. Clark has just given to us, rather than take up the court's time at this point. You sure that those two gentlemen can work it out between themselves as to who's who?
Okay, because there are some people where there are no reports at all on, Your Honor. All right. Thank you, Your Honor.
People that I've just mentioned, they have full reports on. Is the court inclined to entertain the sequestration motion, Your Honor?
I've just entertained it. I've just heard it. Do you have?
I'll be brief. I think this takes the cake for the most transparent motion ever made by the defense. Now that they have everything about Furman has been unleashed, everything that could possibly be said and done about this man has been all over the community, all over Los Angeles. There are posters, there are flyers, there are articles in the papers every day, news, television programs about this all the time. I wonder why the defense wants the jurors to be unsequestered. Gee, I wonder if I can figure this one out. I think anybody can figure this one out. This is, of course, the worst time for the jurors to be.
Would say this is a real no-brainer.
I wasn't even attempting to say that. But I know it's obvious to Your Honor. It's obvious to all of us what they're trying to do here. And it's absolutely improper. I don't even think we need to address it any further because it's so obviously improper. I will tell you one thing. We will rest by Friday unless the defense motions prevent it, because we have voluntarily pared back our list, having seen the fatigue of the jurors and their desire to go home, which we fully understand. Believe me, fully. So we will rest by Friday, Your Honor. It's up to the defense to finally rest and stop playing games, filing spurious motions, asking for more time on matters that they've been fully prepped on for months. Let's just get this thing done. We'll call Gary Sims. His testimony will take 10 minutes. I can give you an offer right now. Gary Sims' testimony, if it takes more than half an hour, we'll all be surprised.
No, we're talking, no, I'm not interested in that. Just the continued full sequestration of the jury as opposed to the modified sequestration suggested by Mr. Cochran and the plan originally contemplated by the court?
The answer is not to unsequester a jury that will be released into a community that is rife with inadmissible matter and very inflammatory matter. That's exactly why they want them released. The answer is to shut this case down. The answer is to end this trial. That's what we need to do. We need to stop with the endless motions and the endless arguments and the endless, requests for time that, for lack of discovery, now they have it. They've got it all. They have everything. With the impressions that the defense complains of will be made available to them, although presumably they should already know this stuff. Their witness testified to it. No surprises are going to be had here. Now, with respect to our timing, I've indicated to the court that unless we get stopped up by a lot of defense motions, we will be done by Friday. And then the defense has to be made to rest at some point. They, too, have to end their case. And whatever witness they have coming, obviously a witness coming this late in the game, we're going to have to scrutinize for relevance and admissibility. That shouldn't take very long. If it's admissible, fine. If it's not, fine. And part of the admissibility issue with a witness newly discovered may well be that witness may engender a mini trial. We have to litigate that. That won't take that long. So if everything goes according to the way it should, and everybody just puts on their witnesses and stops talking, we will finish this case, both defense and the prosecution, by Tuesday of next week.
All right. Thank you.
I must say, I know the officer, we I'm not going to be personal at all. This is just to deal with this motion. We're serious about this motion. I'm mindful of the fact that when we're picking this jury, when the prosecution, the city attorney, and the police released that 911 tape and caused these problems, didn't cause a problem for these jurors. So now we're not worried about what happens in this community. What we're worried about is getting this case over with to the jury. We agree on that aspect. But counsel says, on the one hand, we got to stop all these motions, and she says this mystery witness, whom they know about already, because Ms. Clark turned to Ms. Lewis yesterday, said he must be talking about blank, blank. Peter Neufeld saw her. They know. They've known all along. And in addition,
We're arguing sequestration at this point.
Mr. Neufeld saw her do that yesterday. And
Counsel, let's not get into
all
this.
right. Well, at any rate, the point is they know who this witness is. They should have told us about it earlier at any rate. And so then they argue on one hand we're going to have all these admissibility hearings, as they did with every one of our witnesses. Keep in mind, Judge, they took, what, 6, 7 months? We took like 8 weeks. I mean, you can't even compare that. So we're very serious about this and would ask you not to give it. I don't think it's a no-brainer. I think when you see the fatigue on those people's faces, not paying much attention, staring off into space, coupled with the problem that lady has, coupled with the problem the juror had this morning, we're at a real crisis point, it seems to me. And so I throw this out for Your Honor's wisdom and thinking. I don't think it's a no-brainer. When you spent this much time and this much effort. And if you think, and I'd be real pleased we could finish this case, their part, by Friday. If they do that, we'll finish our part as soon thereafter as possible. But I think that it is not a no-brainer. That's the point I wanted to make.
All right. Thank you, counsel.
Not seeing Dr. Popovich and Mr. DeForest.
I didn't hear their names, counsel.
All right. The other thing I have one thing that'll help you.
What's that?
I have the page references through the Xiphon program for Dr. Gertis's testimony. With
have them
respect
already.
to 303. Do you have them?
I have them.
Okay. Finally, could I request of the court, I will not have an expert, if they're going to deliver these things at 12:30 tomorrow with Mr. Diedrich, I won't have an expert here, and I won't have an opportunity to send them
Counsel,
anywhere.
we litigated this issue
No, I
already.
understand. But what is the ruling? The ruling is they're going to be allowed to put them on in the afternoon after I alone are looking at these test impressions that
You've
I've
heard
never
the
seen
ruling,
before?
counsel. You've heard the ruling. All right. 8:30 tomorrow morning we'll take up scope on the 617 incidents.
I'm requesting adjournment, Your Honor, until Thursday morning for Mr. Diedrich.
Well, you haven't heard Mr. Diedrich yet. All right, one recess. Before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Blazer, Mr. Neufeld, Mr. Scheck. People represented by Ms. Clark, Mr. Dart, Mr. Yokelson, and Mr. Harmon. The jury is not present. First order of business, counsel, I scheduled a hearing on the prosecution's motion to admit certain testimony concerning the defendant's activities, I guess is what we would call it, on June the 17th. That hearing was set for 8:30 this morning. Court was here, defense counsel were here, defendant was here, and we were ready to proceed. The prosecution did not choose to appear in court until 9 o'clock. Is there an explanation for this?
Yes, Your Honor. The person designated to argue this segment of the case had an emergency at home and was unable to make it, and I apologize to the court. But the time has not been wasted. I have been in conference with other members of the team. At this time, Your Honor, we'd like to indicate to the court that we will not be asking to admit the events of June the 17th at this time. However, I repeat at this time because we have not yet heard the end of the defense case, we have not yet heard Sir rebuttal, and I would like to reserve the option of asking to renew our request to admit that evidence depending on what we see in the balance of the defense case in chief and Sir rebuttal.
All right.
We are trimming this case so that we can get it to the jury, and we are hopeful that we can rest the people's rebuttal case tomorrow.
All right, Mr. Cochran, as to the withdrawal of the June 17th witnesses.
Yes, well, we certainly accept that withdrawal. We think it's appropriate, saves you having to waste your time on that. And we accept that, obviously, Your Honor, no problem. I'd like to raise a couple of issues if I might, Your Honor.
All right, well, we're not finished with that yet.
Okay, certainly.
All right. The offer is accepted. However, the failure to appear in court in a timely manner and failure to advise the court, sanction will be $250 to the district attorney's office. That's to be paid by the close of business today. By more or no...
May I remind the court that Mr. Shapiro kept the court waiting for 20 minutes, showing up at 20 after 9 when it was his witness on the stand and suffered no sanction?
Thank
Sure.
you. Sanction will be $1,000.
How much?
1,000.
Thank
Next
you.
question.
Fine, may I proceed right now? Your Honor, with regard to, at the end of the day yesterday, Your Honor asked us not to waste your time. Ms. Clark, on the record, indicated certain witnesses. You'll recall she...
She just got them a $1,000 fine that's be paid today. Oh my gosh. Remember, do you remember, I can't remember if it was Kelly or Josh. They told us there was like $2,500 in sanctions for each side. Paid about that much, I think. I could be remembering wrong. But that's 1,000 of that right there, just today. The trial is almost over. She's... I don't even know what she was thinking.
She said people like the modified fan apparatus video, which you talked about, and the Diedrich and Bodziak and the Bronco fiber issue and the Eckarts and all those kind of things. And you said, don't waste my time, get together. Mr. Douglas went over and talked to Mr. Darden, who told him, I don't know who we're going to call. They gave us no proffer, no offer of proof, no cooperation, no nothing. So we don't want to waste your time, Judge, but when they won't talk to Mr. Douglas, what are we going to do? So the problem is, and they said they don't know who they're calling. If, Judge, they are saying they're going to finish this case by Thursday or by Friday, then we're entitled to all the rest of their witnesses. We're entitled to the end of the witnesses. And all we're trying to do is get somebody to talk to us so we can resolve this matter. We want to resolve it. If they really want to get...
How dare you? How dare you guys do this again? You stand up and ask for the witnesses, and you won't give your witnesses. Marsha has asked over and over and over again, how dare you? Okay. I'm gonna have to get some rum.
Get this case to the jury. We like our proffers. We like to know who they're really going to call. Now the 17th is now out, and that's fine. And so we just like to have, would you direct them to meet with Mr. Douglas right now so we can get this done, Your Honor?
I met with Mr. Douglas. Good morning, Your Honor. I met with Mr. Douglas yesterday afternoon. I gave him approximately 6 names. That included Sims, Diedrich, Bonziak, Lawrence Acker, Nancy Acker. What other names did I give you, Mr. Douglas? I don't know what he's talking about. I've given him the names.
And Mr.
Okay?
Douglas can speak
I
for
gave him the
himself.
names. If Mr. Douglas says that isn't correct, he was writing on his pad. I was standing right here yesterday.
Today
late
is
afternoon.
September
That isn't true?
13th.
Is that true?
I asked him
September
what
13th,
order
part
is
one.
going to be called following Sims. Mr. Darden said, I do not know. I asked him this morning. He gave me these names. I asked, what order? Who's next after Sims? This morning, he said, I do not know. If I'm mistaken, please correct me.
Right. But he gave you the witnesses. He's given you 5 or 6 names, correct?
He did, Your Honor. And I asked who follows Sims so that I can have the person who does that witness ready after Sims.
So, Your Honor, what we're saying is she gave us some names in court, but we want to know who's up next, what's the offer of proof.
They've given you the names. We know who Bodziak is. We know who Sims is. We know who Diedrich is.
In other words,
About the
sit
actors. We're
down.
trying to get the actors
and
here from
shut
out
up.
of the country to testify tomorrow, so they won't be here today.
All right. Testify as to what?
Heitstra issues.
Heitstra. Okay.
Your Honor.
And they have the discovery.
All right, Your Honor, and may I inquire, are they still planning to rest and by tomorrow or Friday? Because then we would be entitled to anybody else they have. It's within the 3 days, and we're just trying to find out who
Well, I
else they
assume
have.
that's their case. They tell me that they're going to rest tomorrow or Friday.
All right, that's fine then, Your Honor. The last thing is, Your Honor, the next thing I'd like to, we're going to have to address at some point this Bronco fiber issue, which we think shouldn't take the court very long. Speaking of no-brainers, but we're ready to do that whenever you want to. The last thing is, we would like to have Agent Martz, FBI Agent Martz, back here and need this court's assistance for, if they're going to rest truly on Thursday or Friday, for our case on Monday, September 18th. We'd like to request that now, so we'll have him here. In addition to that, we expect to call Special Agent Whitehurst of the FBI, and we expect that hopefully Mr. Scheck has started a procedure by which hopefully justice will make this person available. He's a critical witness in this case, and it will tie in with the March testimony, so that there's no delay in that regard.
All right, if there are any interstate subpoenas that need to be issued, submit them to Mrs. Robertson
All right.
as soon as you can.
Thank you. May I have 1 second? Your Honor, so we're trying to save downtime. We will work on that today. The last thing is, Your Honor, on this whole issue, if the Ackert or anyone's call with regard to Robert Heitster's testimony, we need Detective Dennis Payne, who we understand is retired, and we want to put him on notice now. We need Payne if he's out of...
Is Payne the one who took the
yes, he took
statement
the
from the Ackerts?
From Heitster. No, from Heitster.
From Heitster.
Heitster. And we need him right away, so we need your help, and we want to put him on notice. We want Payne, so there'll be no downtime on that as soon as possible. Might as well have him here Monday.
They should contact the LAPD. At any event, they marked Mr. Heitster's statement. I'm not sure, but I think you admitted it in the evidence.
We want Dennis Payne.
Well,
So that's the issue on that.
they
All
call
right.
the LAPD.
Then you're not willing to make him available?
He's retired, Judge. I can't make him available.
All right, you'll have to subpoena him.
You get an address or something, Your Honor?
Penal Code section never precludes from giving them the address of the retired police officer.
Yeah,
All right,
that's
well, counsel, what we'll do is, I don't care about this fight between the parties. I'll have my staff contact the LAPD and make them
Thank you, Your Honor. That's
get their cooperation to produce him.
And producing for Monday, Your Honor. Thank you very
Well,
much. Or as soon thereafter.
he's retired. He could be in Florida. Who knows?
Well, we'll try to, as with other witnesses, we don't want to let this trial. We pay for him to come back.
All right.
Your Honor, with respect to Agent Diedrich, if I understand it correctly, he's supposed to be here, arriving here at 12:30 with the last representation, and Mr. Morton is going to be able to get here at 12:30, 1 o'clock. I at least would like the opportunity to look at the underlying data from the report that they just gave us. I do get that
issued that
opportunity.
order yesterday.
I
That they're to-
understand.
As soon as the exemplars or the impressions are here, you're entitled to look at them, to see them. You're entitled to access to that. We dealt with that issue yesterday.
No, I understand that, but just wanted to make clear we're going to get that opportunity, and that includes the jeans, the envelope, the shirt.
The whole enchilada.
Well, all right. I just want to put, in terms of scheduling, I want to put the court on notice, and
All right.
Yeah, we need to, number one, we need to be heard with respect to the admissibility of the Whitehurst issue. And we're prepared to argue that so that we do not waste time trying to locate a witness who I believe has testimony that has nothing to do with this case and is irrelevant. So, we're going to go into downtime to make him available when he has no admissible evidence. Secondly, I'd like to argue the Bronco fiber motion.
Well, let's do this. Let's proceed with your next witness this morning with the jury, because the jury's expecting testimony now. As soon as we complete that phase of your presentation, where do you anticipate going after that?
Well, we had wanted to go with the Ackards since they're not available immediately. I would like to, we may have a little downtime because we have to fly witnesses in. The Paratus tape presented with the testimony of Steve Oppler, and we have, which we've edited and will show to the court. And then we would intend to call Doug Diedrich, any fiber witnesses that we're allowed to call, and Bill Bosniak. But they won't be ready for testimony until tomorrow morning. So we might have...
All right, so then the point of my asking you that question is that we don't need to resolve that issue now. If there's going to be downtime for witnesses, we can use that time to argue the motion.
Well, the problem is I don't know whether to notify the witnesses to come in or not until the court rules.
Where are these witnesses coming from?
Washington, I believe. They're fine. They're not in state.
Okay.
And I didn't want to fly them out if the court was going to... they're on standby. I have them on call, but I'm not going to spend the money to have them out unless you stay.
All right. Mr. Cochran, who on your side is going to argue the Bronco fiber motion?
I believe it'll be Mr. Laser.
All right, are you prepared?
Yes.
All right, I'll hear the argument.
I believe we're the moving party, Ron.
Yes. I just wondered who was, if they were ready, you're ready?
I'm ready. They're ready. As my moving papers have indicated to the court, we believe that the evidence is admissible and proper rebuttal for two reasons. First of which is, I believe we appended to our motion the transcript sections from the testimony of Kathleen Bell as elicited by Mr. Bailey, in which he gratuitously asked her questions concerning the kind of car Mark Furman drove, or she believed he drove, back when the statements were made. There was no purpose, no legitimate purpose for asking that question unless it was to, other than the one we're arguing they were trying to infer, unless it was to show that she in fact did know him and therefore could identify him. That argument, however, falls as specious because there was never an effort to link up the car she described to any car known to be driven or owned by Mark Furman, which could have been done through DMV records or any other people who knew him at the time, including the police department. No such effort was made. And it is clear that the motivation for asking those questions and eliciting not once but twice that she saw him driving a sports utility vehicle was to have the jury infer that he preferred that kind of vehicle, and therefore the fibers could have come from that vehicle. And as the court recalls, Mr. Bailey was the one who handled the hair and fiber evidence with us and is most acquainted with the issues concerning the admissibility of the Bronco fiber study that was conducted by Agent Diedrich. That's on one hand. Secondly, with respect to the attack on Mark Furman's credibility, as the court is aware, an all-out attack was launched on his credibility and has become the cornerstone of the defense case. Anything in the case in terms of scientific or objective evidence that tends to indicate that the glove was not planted and that he was not responsible for the planting is naturally relevant as a rebuttal to that claim. Having found Bronco fibers on the Rockingham glove, and that's key. It's not the Bundy glove, it's the Rockingham glove, and that's the one they're claiming was moved. That is key to establish that, in fact, it was not planted because the fiber on that glove came from a rather unique source, not just any car, which is what otherwise they could argue, or even any carpet in a house, but a very unique fiber that was made during 92 and 93 and put into 94 vehicles, a fiber whose configuration in terms of the cross-section and the dye formulation was changed later in 94 and had not been made prior to 92. Moreover, this is a fiber in which carpeting was used for only 3 kinds of cars, predominantly for the Bronco, more secondarily in much fewer number, Econoline vans and F-Series trucks. So you have very highly probative evidence found on the glove that could not have been planted, that would tend to rebut the claim that the glove was planted by Detective Furman. So we have 2 independent bases on which to admit this evidence now, which makes it proper rebuttal. People have cited the cases to the court that indicate why this is an admissible rebuttal and why it is proper to address this at this time. The court is aware, of course, that the discovery has been given to the defense on this, so there's no element of surprise here. The witnesses that would be called to prove this evidence would be 2 at maximum, 3 in number, of very short duration. 1 to talk about the fact that the fiber of this cross-section was made during these years, sold to Masland. Masland representative will say that fiber was put during these years with this dye formulation into these cars. And that's it. And then Doug Diedrich to say, and that's the fiber I saw. That testimony collectively for all 3 witnesses should not take an hour. So we are not talking about an undue consumption of time either, but I do think it is highly probative and certainly important to rebut the claim of any evidence movement by the defense, especially the Rockingham glove.
Mr. Blazier?
Morning, Your Honor. As the court will recall, I believe it was with Susan Brockbank, I asked a series of questions about whether they had checked other vehicles. And I asked those questions based on representations that had been made to us by the manufacturer of this fiber that it was very, very common. Unbeknownst to me, that same person, the actual person that we had talked to, had already provided written documentation to the FBI as part of their investigation of the source of the fiber that they titled it. That was just completely the opposite. And it was only after that point that Mr. Diedrich came in and brought his paperwork. I asked him a number of questions before he testified to try and find out what he had, and he was very, very evasive. Finally, the court had to intervene and make him have a copy of his whole binder made. And in that binder is this very, very detailed report where they had done a thorough investigation months before. I think it was a 7 or 8 page report titled "The Source of the Fiber." And the court, properly so in our view, precluded the prosecution because of misconduct from putting on any of that evidence because it had been held back and not turned over in a timely fashion prior to our conducting our cross-examination of these witnesses. We were extremely careful after that point to not ask a single question about rarity of Bronco fibers. We didn't ask anybody about that because we did not want to open the door. Now, as I understand the argument, well, first of all, I think it's interesting that Ms. Clark has argued many, many times that there's absolutely no evidence that Detective Furman planted the glove. Now she feels the need to bring this evidence in to show that Mark Furman's carpet fiber is not on the glove. We have never said that. We've never maintained that. The references to his green utility vehicle were it was obvious what the purpose of that was. It was to demonstrate that Ms. Bell recognized his car and had seen that same car with him in it on a couple of other occasions. If the prosecution is concerned that we would argue that the car that Mark Furman drove in 1986 might have a fiber that matched the fiber on the glove, they can put on a witness to say what kind of fiber was in Mark Furman's vehicle. That would certainly solve that problem. That's not the reason they want to do this. They want to do this because they think that was powerful evidence It was precluded before because of their misconduct, and now they're trying to find a way to get it in. This is just a ridiculous argument. And we haven't offered any testimony about what vehicle Mark Furman drives. We don't intend to. We would never argue that. That's a ludicrous inference. It's not believable. It's not a justification for putting on this evidence that was wrongfully withheld before.
What do you think about a restriction if I maintain the preclusion, a restriction on argument as to the rarity of the fiber and the lack of evidence thereof?
Well, if they're allowed to put on evidence about the rarity of the fiber, then the effect of the preclusion is nil. I mean,
No, you misunderstood my comment. If I maintain the preclusion, that's likely to include a preclusion of argument.
oh, absolutely. That's no problem. We don't intend to argue that.
Maybe just a second here.
Not stated in the record, I assume, is what you mean. We don't have any problem. We're not going to make any argument that we know is misleading based on information they've obtained. I have no problem with that. I assume that's what you were suggesting.
I'm just asking.
Yeah, that's fine. We didn't plan on arguing that anyway. We don't want to do anything improper in closing that might allow them to come back and ask to have the case reopened. That would be foolish.
All right, thank you. Ms. Clark.
I don't know why they're trying to hide the truth. Doesn't the jury have the right to the very best evidence that exists? We have evidence that is very powerful, that is further evidence of the defendant's guilt, and to simply preclude them from arguing that it was Mark Furman's vehicle does not go anywhere near addressing that issue. Furthermore, if there is to be a preclusion in the alternative, Your Honor, then the preclusion should include their ability to argue that any police officer's car could have imparted those fibers, because that is in fact the case, and that would in fact be the testimony.
I accept that. I mean, I assumed that what you were referring to, we would not make the argument that it could have been in any police car. We would not make that argument.
All right. Thank you, counsel.
Your Honor, I just think the rarity of the fiber is very probative evidence for the jury of the defendant's guilt. And I think that given the nature of the attack in this case and the arguments about planting of evidence, it becomes even more probative. And I think it's evidence that the jury should hear.
All right. Thank you, counsel. The reason for the court's initial preclusion was the failure to disclose the report, which gave indicia of extensive investigation as to the source, nature, and rarity of that particular fiber. That information was not turned over during the course of discovery as required. The court felt that preclusion at that time was the appropriate sanction. The proffer at this time is that Kathleen Bell testified that she observed a pea green utility vehicle at the Marine recruiting station at a time that coincided with Detective Furman's presence at that location. She then testified that she saw Detective Furman in a business establishment in that same general area, and that on another occasion also saw the same pea green utility vehicle at that location and chose not to enter the location, fearing that Detective Furman was again there and not wanting to reacquaint herself with him at that time, given the nature of her testimony. These events occurred in 1986. There was no contemporaneous testimony indicating that Detective Furman had any contact with the same vehicle. The testimony was that Detective Furman drove to the Bundy location in a police vehicle with Detective Phillips. The proffer has no probative value, and the court's previous ruling stands. All right, let's call our next witness.
Just one quick.
Yes.
All I ask is, I was out of the room for a moment when I heard that they wanted to do the Paratus tape next. All I'm saying is, in light of your instruction yesterday that they edit it, I haven't seen the edit yet. I would just ask
No,
that
I indicated to you we were going to look at it one more time before it's played. I want to see the edited as well.
Right, because I may have objections to that. Thank you.
All right. All right, Deputy McNair, the jury's upstairs still? All right, we're going to proceed with the next witness, who I take is Mr. Sims. All right, while we take the recess to bring the jury down, I had to pull a number of the Bronco exhibits for the purpose of reviewing last night. Mrs. Robertson has them available. Get your exhibits organized. Let's not lose any time fumbling with exhibits.
I need it.
All right.
Nice.
All right. We'll take 15 to bring the jury down. Get your exhibits in order. This one down for a moment, please. Since I need to see the eyeballs of the jury from time to time. As the case may be. All right, Deputy McNair, let's have the jurors, please. Ladies and gentlemen, please be seated. All right, let the record reflect that we've now been rejoined by all 14 members of our jury panel. Good morning, ladies and gentlemen. Better. All right, Mr. Harmon, you may call next witness.
Thank you. Good morning, ladies and gentlemen. People recall Gary Sims.
My name is Gary Sims, G-A-R-Y-S-I-M-S.
Thank you, Honor. Mr. Sims,
Our little puppy is back,
you conducted
guys.
additional testing that you're here to provide the results on in this case?
Yes.
He got a
And just
haircut.
to put the additional testing in context, I'd like to put up a couple of exhibit boards, People's Exhibit 260 and People's Exhibit 172, which are the Bronco photo board, or the Bronco result board and the Bronco photo board, respectively. And start out by just briefly discussing items 31, 303, 304, and 305 that you previously presented to the jury. Item 31, if you look at the result board, that was on the center console, shown in one of the photographs, and you provided some PCR results from that. Is that correct?
Yes.
And would you just summarize what the results were and what your conclusions were without addressing any statistical aspects of those conclusions?
Yes, for item number LAPD 31, which is our item number DNA 18, the DQ alpha finding indicated a main type of 1.1, 1.2, a minor type of 1.3 and 4, and those alleles are consistent with a mixture of the defendant, Mr. Simpson's blood, and Mr. Ronald Goldman's blood. And then on the D1S80 results for that sample, the call on that was 24,25. Again, that is consistent with this same mixture.
Okay, and would you give us the same summary with respect to item 303, which was from the center console as well?
Yes, item 303 was our number DNA 52. The DQ alpha type on that was a 1.1 with a possible 1.2, 1.3, and 4. The D1S80 type was 24-25 with a weaker 18 allele.
I'm so mad. I am so happy to see Gary Sims again, our puppy. I'm so happy. But I am so mad I have to look at this board again. If I never, ever, ever, ever see this board again in my entire life, I will live a happy, happy life.
Particular mixture was consistent with a mixture of the defendant, Mr. Goldman, and also Nicole Brown.
What about 304?
304 was the same results. That was our item number 53, DNA 53.
Same as 303.
That's correct.
And what about 305?
305, in the case of 305, there was a slight difference there in that the DQ alpha type was called a 1.1, possible 1.2. The minor type in that case was a 1.3 and 4.
And what conclusion would you draw about possible sources from among the three parties whose reference samples were provided to you in this case?
Well, I would also supplement that the D1S80 results were the 24 and 25 alleles along with a weaker 18 allele. So again, that was consistent with the mixture of all three of the the principals in this case.
Okay. I want to ask you a general question with regard to your PCR processing of each of these console samples that you've provided a summary of your results on. Were any of those console samples ever extracted in the presence of any of the reference samples during your handling of these samples in this case?
No.
Are you familiar with Dr. Gertie's testimony with regard to some of your results in this case?
Yes.
And what's the basis of your familiarity? Have you read excerpts of his testimony?
I listened to some of his testimony when I was monitoring it. I also have read some of the transcript.
And have you also been provided with a copy of a defense exhibit in this case, defense exhibit 1309?
Yes, I believe is that the... I'm sorry, could you explain which one 1309 is?
Well, once you take a look at it, it appears to be a photo of a set of DQ alpha strips. Why don't you take a look at the photo in the left-hand corner and see if you recognize the photo of the complete set of strips reflecting work that you did in this case?
Yes, I do.
Could you briefly summarize, and I want to solely ask you to focus on LAPD item number 31, the center console item that you just provided us a summary of your results for. Could you describe, based on your reading of Dr. Gertie's testimony, the nature of his concerns about item 31, and solely with respect to the DQ alpha testing?
Objections to summarizing the testimony.
Rephrase the question.
Sure. What are the concerns that Dr. Gertie's expressed with regard to item 31?
Same objection.
What's the first concern?
What is the first concern that Dr. Gertie's expressed with regard to, specifically with regard to LAPD item 31?
The concern that I was aware of was the determination as to whether or not that 1.3 dot was in fact a real allele showing up or an artifact. That was his concern.
Okay. Do you agree with the concerns that Dr. Gertie's expressed to this jury when he testified and discussed Exhibit 1309?
Well, I disagree with him in that his conclusion was that one could not say with confidence that the 1.3 allele was there, and I disagree with that.
And solely focusing on LAPD item 31 and the testing that you actually performed, and you're the only one that performed testing on that sample, why do you disagree with him?
Well, just for the record, I should state that this analysis was performed by Renee Montgomery, and I was the second reader on this particular date.
Okay.
I disagreed with him because of the relative intensity of the 1.3 dot in this case relative to the C dot within this particular strip.
And what's the basis for your opinion that you're correct in calling that?
Well, the call that was made at the time that this strip was developed included the findings of the 1 dot, the 4 dot, the 1.1, the 1.2, etc., the 1.3, and the all but. And the finding of these two dots, the weaker dots here being the 4 and the 1.3, was that they were of similar intensity to the C dot.
In an effort to unravel or determine the potential sources for all of the blood stains that were tested on the console, on the Bronco console, did you continue to perform testing on items 303, 304, and 305? Continue beyond what you've already described to this jury?
Yes.
And what, just generally, what did you do?
What I ended up doing, what I ended up doing was noting that the overall quantity of DNA that was individually extracted from those three samples, 303, 304, and 305, appeared to be insufficient for an RFLP type analysis. So what I did was to individually look at the types from those samples, and then I made a determination to combine those extracts, the extracted DNA from all those three samples, to get enough DNA so that I felt I could get an RFLP result by the collective, the bringing together of those three samples from the center, all from the center console.
We're going to talk about that a little bit, but would you just describe the relative amounts of DNA that you detected in those individual samples, 303, 304, and 305?
Yes, I can do that. I need 1 second to refer to my notes. From 303, which is our item DNA 52, there was about 40 nanograms recovered in that original extract. From 304, which is our DNA 53, there was about 29 nanograms. And then in the original extract of 305, that was around 17 nanograms approximately.
Now, why did you feel it was appropriate to combine those stains in order to pursue the RFL, or strike that? Why did you feel it was necessary to combine those 3 stains in order to try to perform RFLP testing to produce results from those stains?
Well, it was clear to me that we had a mixture of DNA of DNAs from different individuals in these samples. And individually, for a typical individual stain, we like to get about 50 nanograms to test in our laboratory for an RFLP analysis. And I knew that given these were weaker mixtures, that it would be very difficult to get that kind of DNA to show up on one of these autorads that we've seen so many of without having enough quantity. So the only way I felt that I could get enough quantity to do that was to combine them. In other words, I could individually test them for these sensitive PCR tests, but to get enough for one of these RFLP results, I felt that I had to combine them.
Okay, and why did you feel it was scientifically appropriate to combine those 3 stains in order to perform RFLP testing?
Well, I looked at this in a very stepwise fashion in terms of looking, first of all, at the consistency of the PCR results in the different systems that we tested, DQ alpha and B1S80, also knowing that they were all collected from the center console of the Bronco. I felt that, in my forensic opinion, that was the same general blood-stained area, so that it would be reasonable and certainly feasible to combine them.
In your opinion, do your RFLP results, which we will show to the jury in a few minutes, on the mixtures that you've just described for us, do they corroborate your interpretation of item 31, the center console, where you concluded that the possible sources would be Mr. Simpson and Mr. Goldman?
Yes.
In what sense do they corroborate them?
Well, the finding of those, of the RFLP patterns that are consistent with those 2 individuals, Mr. Simpson and Mr. Goldman, tends to corroborate the results in item number 31, which is also a center console bloodstain.
Had you finished your answer?
Yes.
Okay. And in your opinion, do your RFLP results, which we'll show to the jury in a couple of minutes, do they tend to undermine the reservation or criticism expressed by Dr. Gerdes that you've described to the jury just a few moments ago?
Objection. Move to strike. It's not Dr. Gerdes' testimony about 303, 304, and 305.
Leading, rephrase the question.
Mr. Sims, in your opinion, do your RFLP results from the mixtures that you've performed or that you've just briefly described to this jury, do they tend to undermine Dr. Gerdes' opinion?
What's the impact?
Mr. Sims, what's the impact of your RFLP results on the combination of 303, 304, and 305 on Dr. Gerdes' criticism about the 1.3 allele in item number 31 from the center console?
Objection. Move to strike with respect to item 31.
Overruled.
Well, I think the RFLP results do tend to undermine that because they do show consistency with what I originally called on item number 31, which Renee Montgomery also called on item number 31, namely that those DQ alpha results were consistent with a mixture of Mr. Simpson and Mr. Goldman.
Okay. In addition, Mr. Sims, do your RFLP results from the combined stains on the center console also corroborate the PCR results that you've briefly summarized from those same stains on the center console?
Yes.
In what way?
Well, again, the finding on the RFLP results is that it is consistent with a mixture of Mr. Goldman and Mr. Simpson. You'll recall that on the PCR results we saw a little bit of this 18 allele. This was the weak allele on the D1S80 results on those gels. I believe what we're seeing is that weak type that is detectable by the very sensitive PCR methodology is not detected by the less sensitive RFLP approach.
And what do you say about the remaining types that are consistent with Mr. Simpson and Mr. Goldman from the PCR? Is that what you see in the RFLP results?
Yes.
Mr. Sims, do the combined stains from 303, 304, and 305, the RFLP results, tend to address any concerns about PCR's exquisite sensitivity?
Yes, I believe they do, because you've heard extensive testimony about the sensitivity issues with PCR. The RFLP is not as vulnerable to those concerns as the PCR is.
Mr. Sims, do the mixture results from stains 303, 304, and 305, the RFLP results, tend to address concerns about potential cross-contamination among samples?
Objection. Strike.
Overruled.
Yes, I believe they do, because to get an RFLP result, you need a substantial amount of DNA from a blood sample, particularly when you're comparing that to how sensitive the PCR test is.
Okay. Your Honor, at this time, I'd like to have marked as people's next in order a set of 4 autorads in a plastic cover. What would that number be?
Mrs. Robertson, Peoples next in order. 616.
616? And-
Six-
I'm sorry?
Did you want to mark them 616 A, B, and A, B, C, and D?
Yes, and I'll describe, so we can correlate them later without actually marking. I'll describe the order that we'll be showing them. As 616A, the autorad is labeled D10S28. As 616B, it's the autorad D4. As 616C, it's D5. As 616D, it's D2, Your Honor. Mr. Sims, I'd like to show you a set of 4 autorads, 616A through D, and would you tell us if those represent the 4 autorads that were produced as a result of your combination of those 3 stains, 303, 304, and 305?
Yes, they do.
And we've actually put labels on them that you didn't put on there to show the names and identify the stains. Is that true?
That's correct.
Okay, Your Honor, I'd like to show them to the jury and have Mr. Sims use the telesurvey. I'd like to show 616A. Here.
Can we clear these artifacts? Mr. Harmon, we appear to have artifacts on the telestrator. There we go. Thank you, Ms. Martinez.
Mr. Sims, can you help get the jury reoriented on the autorad reading 1 here and describe what they're seeing so they can understand the results?
Yes, this is now an autorad from a gel which contains the combined 303, 304, and 305 from the console, and that's labeled console in that particular lane. And you recall these samples run downwards from the top to the bottom in the vertical lanes. Then we have a reference sample from Mr. Goldman, we have a reference sample from Mr. Simpson, and then a reference sample from Nicole Brown to the right side there.
Okay, and so the lane that's labeled console, that represents the combination of 303, 304, and 305?
Yes.
Is that right? And the reference samples is Mr. Goldman, Mr. Simpson, and Ms. Brown?
That's correct.
Could you describe your results and what your conclusions are without addressing any statistics?
Yes, the finding of that pattern in the console lane is consistent with a mixture of the banding pattern of the defendant, Mr. Simpson, and also the contribution from Mr. Goldman.
Could you, is there any way that you can show which bands match which by using different colors for the different reference samples?
Yes.
Why don't you do that?
I'll mark the lanes in the console in, I guess that's a sort of a lavender or pink color, that are consistent with the defendant's bands. And I'll also mark those lanes, I'll mark those bands in the defendant's, Mr. Simpson's lane.
And then what about there seems to be, on the reference sample of Mr. Goldman for this probe, it looks like he's just got one band. Is that true?
Yes, this was scored as what we call a single band pattern down in this area. It's possible that he has 2 very close bands in this area, but they tend to run together in all the samples that we saw in this case every time we ran his sample. It's a single band pattern. So instead of having 2 bands, he just has 1 that's scored. And I'll mark in green his position in his reference lane, and now I'll mark that band also in the console lane. The other thing that's significant to me in this particular mix is that...
Excuse me, Counsel. Not responsive to a question.
Is there anything else that's significant to you in this particular mix?
The other thing I wanted to mention, and we'll see this as we go through the total picture of these different autorads, is that the bands that are consistent with Mr. Simpson's sample are consistent with the stronger bands in the console lane, whereas the bands that are consistent with Mr. Goldman's sample, his reference sample, are consistent with the weaker bands in the console lane.
And is that true with each of the 4 autorads that will be shown to the jury?
Yes.
And does that somehow relate to the amounts of DNA in those, in your opinion?
It relates to the relative contributions from each individual.
Mr. Harvey, you want to print this out?
Yes, Your Honor, may that 616A1? And can we, as soon as we're ready, put up B? Okay, Mr. Sims, we're looking at 616B now. You've already given the jury the orientation on that. What do these results reflect, in your opinion?
This is an autorad developed from the locus D4S139. Perhaps we can brighten that up a little. That's pretty good.
Is this the best way to look at autorads, projecting them up on the screen?
That's not how we do it in the laboratory.
You look at it on a light box?
Yes, we study them under a light box,
Okay.
or over a light box.
Sure. Why don't you describe what you observed and what conclusions you drew from 616B?
Yes, from 616B, again, this is the locus D4S139. Again, the console lane has, in this case now, 4 bands. This is consistent with a mixture of the defendant's sample and Mr. Goldman's sample. And I will mark the bands again, as I did previously in the console. Console lane, I'm marking in the pink or lavender the bands that are consistent with Mr. Simpson's bands. And now I'll mark them in his reference lane. And now I'll mark in green the bands that are in the console lane that are consistent with Mr. Goldman's bands.
Now, in this instance, Mr. Goldman's reference type and the corresponding evidence stain have 2 bands, is that correct?
That's correct. He has a 2-banded pattern, which is the typical pattern in an RFLP, is a 2-banded, but sometimes you'll see 1, for example. And now I'll mark in green the bands of Mr. Goldman in his reference lane.
And I neglected to ask you this with regard to 616A, but Ms. Brown is excluded as a source of any of the typing results on the console combination. Is that true?
I didn't detect her band pattern in these autorads.
And the pattern you detected was inconsistent with her?
Yes.
Okay. May that be marked as 616B1, Your Honor? Can we put up 616C? Why don't you describe what's of significance in 616C, Mr. Sims?
Again, this is the same gel, but now this is the locus D5S110. Again, we see a pattern in the console lane that is consistent with a mixture of Mr. Goldman and Mr. Simpson. Again, the bands that are the strongest in that console lane correspond to Mr. Simpson's bands. The 2 weaker bands correspond to Mr. Goldman's bands.
Could you mark them with the corresponding arrows and colors that correspond to 616A1 and B1?
Yes, I'll use the lavender arrow to indicate the bands in the console lane that are in agreement with the bands seen in the defendant Mr. Simpson's reference lane. And now I'll mark those corresponding bands in Mr. Simpson's reference lane. And now, switching to the green arrows, I'll mark the bands in the console lane that are in agreement with the bands in Mr. Goldman's reference sample. And now I'll mark in green the corresponding bands in Mr. Goldman's reference lane.
Okay, may we capture that as 616C1, Your Honor?
Yes.
Okay, we're looking at 616D now, Mr. Sims?
Yes.
Why don't you describe to the jury what you see on there and what conclusions you drew from the results?
Yes, this is now the locus D2S44. This is the final autorad I'll show you today. This is a more difficult call on this particular lane with regards to the console, because you can see that Mr. Goldman and Mr. Simpson have fairly close bands as far as their upper bands are concerned, and I'll talk about that as I look at as I explain to you the console pattern. But I think you can see. I'll point with the lavender arrow at the bands in the console lane that are in agreement with Mr. Simpson's bands. And now I'll mark those corresponding bands in the lavender color in his reference lane. And now with the green arrow, I'll first mark, I'll go backwards a little bit here. I'll first mark the bands in Mr. Goldman's reference lane, here and here. And now we'll talk about the console lane, because this is a little more difficult to see. There's a band in this position, this lowest position in the console lane where I'm pointing now with the green arrow, that is in agreement with Mr. Goldman's lowest band. Now the difficulty arises when looking at this particular area right above the band that corresponds with Mr. Simpson's band.
The upper band.
The upper band. This autorad was reviewed by myself and then independently by a second reader. We felt that there was an indication of a band here, but we could not score that as a clear band. In other words, it's not clear and distinguished enough that we could make a determination that that is a band that's sitting on top of that one band. They're just too close to call, and it's just not clear enough. And so we did not score that as a band.
It's too close to what?
It's too close to the band that corresponds to Mr. Simpson's band in his reference sample.
Okay, and if what you see there really is a band, does that correspond to Mr. Goldman's other upper band?
Yes, it would.
Could you point to the area that you believe you saw some activity?
Yes, I'll point to it with the, perhaps I should use another color.
That's okay. We've described it as upper, so.
Okay, I'll point to it and mark it with the green arrow.
Okay, can we capture that as 616D1, Your Honor?
Yes.
And actually, is there a fifth probing going on as we speak?
Yes, there's another film that if I get back today, I'll look at this afternoon.
Okay. Mr. Sims, why don't you go up and have a seat? I just have a couple more questions here. Mr. Sims, is there any question in your mind that the RFLP results that you've described to this jury represent a mixture from more than one source?
No, there's clearly a mixture of DNAs in those samples.
And you've already described to the jury the significance of the relative intensity differences in the bands, and you can see what they are, especially on 616D. Is that true?
Yes.
What significance is there to the fact that you never observed more than 4 bands in the combined stain from the console?
That would indicate that we are seeing most likely DNA from just 2 individuals, not more than 2 individuals.
And just to make sure there's no confusion, because of the relative sensitivity of PCR with respect to RFLP, these RFLP results in no way undermine or contradict the PCR mixture results you previously provided to the jury. Is that correct?
That's correct.
Okay. Thanks, Mr. Sims. Okay.
5 minutes, or let's take a break?
Let's take a break.
Your Honor, I neglected. We have a patch. I just wanted to complete his testimony by placing this patch on.
Well, why don't you ask?
Can we do that on
Go
the
ahead.
record?
No, why don't you do it on the record? Go ahead. And also, Mr. Harmon, let's say, right.
Okay, may the record reflect on the Bronco result board. I'm placing vertically to overlap the RFLP column on 303, 304, and 305, a label that says console mix 4 probes.
Okay. So noted. All right, ladies and gentlemen, we're going to take our mid-morning recess at this time. Remember all my admonitions to you, and we'll see you back here in about 15 minutes. All right, Mr. Sims.
Do you know how much I can do in 15 minutes? A lot, Judge, a lot. Wow, see?
All right, back on the record in the Simpson matter, all parties are again present. All right, Deputy McNair, let's have the jurors, please. Be joined by all the members of our jury panel. Mr. Sims, would you resume the witness stand, please? All right, Mr. Harmon has completed his direct examination, and Mr. Scheck, you may commence your cross-examination.
Thank you, Your Honor. Good morning, ladies and gentlemen of the jury. Mr. Sims, good to see you.
Good to see you.
Let's see if we can.
All right, you're going to put up again Peoples 172. Yes. All right. Got it?
And if we could look, just to clarify some of the facts here, at Peoples 172 and also the results board, Peoples 260, to understand precisely what you have done here. Now, first of all, items 30 and 31 are depicted in the upper right-hand corner, is that correct?
Yes.
Of the Peoples 172. And those represent swatches that were made on June 14th.
Yes, that's my understanding, that those two stains were collected about June 14th.
On June 14th by Dennis Fung and Andrea Mazzola.
I'm not sure who collected them, but the date sounds right to me.
And each picture on this board, 29, that's the steering wheel you told us about, right?
Yes.
All right, that's the one with the 1.1, 1.2, and 4, correct?
Yes.
And the next picture over 33, another picture of the steering wheel, 29, 33 again, 22, 23, 34, the picture just showing 25, 26, 27. All those pictures were of collections made on June 14th, 1994. That's your understanding, correct?
That's my understanding.
And 293 is a carpet that was pulled out of the Bronco on June 14th, correct?
That's my understanding. The carpet was pulled out on that day.
All right. Now, samples 303, 304, and 305, those are the samples that you combined to do your new RFLP test, right?
Yes, 303, 304, and 305.
And they are depicted at the bottom right-hand corner here from the console.
Yes.
And those stains were collected on August 26th, correct?
Yes, my understanding is it's about that date.
Okay. Now, the results you got on the Bronco samples that were collected on June 14th are shown in the result board here. That's 30 and 31, correct?
Yes, I believe those are the ones, although 34, I think, and 29 were also...
I'm talking about the console.
Oh, console, I'm sorry, 30 and
That's
31.
my question,
Yes.
right? The console.
Yes.
Now, 30 is depicted in the upper right-hand corner. From that swatch collected on June 14th, you got a 1.1, 1.2, 24, 25, correct?
Yes.
And that is a DNA typing that is consistent just with Mr. Simpson.
Yes.
And from that typing, there's you can exclude Ronald Goldman and Nicole Brown Simpson.
Yes, none of their DNA shows up in that sample.
Okay. Now, the result from 303, the sample taken on August 26th, right?
Yes.
All right. Which is that one on the DQ alpha and D1S80, you got results that were consistent with Mr. Simpson, Mr. Goldman, and Nicole Brown.
That's correct.
And in theory, it's your understanding that 30 and 303 were taken from the same area.
Objection calls for speculation. This states the testimony.
Sustain.
Is it your understanding that 303 and 30 were supposed to be bloodstains in the same area?
Objection, next day calls for speculation.
Oh,
I remember we went through all this in May, and I think we got down to the issue of what are we talking about when we're saying it's exactly the same area?
I didn't say exactly the same. Same general area?
Same general area, yes.
Right?
I would agree
That's
with
what the reports you got indicated.
that. Same general area.
Thank you. Now, 31, okay, that's the second stain from the console from June 14th, right?
Yes.
And that's the one that you say has a DNA, a DQ alpha profile that is consistent with Mr. Goldman.
Yes.
All right, now. Your Honor, for the sake of, I don't know if it can be seen at the end, so I'll just try to put it on the middle. Now, Mr. Sims, 31,
All right, I'm sorry, Mr. Chair, you just put up defense exhibit.
1309.
Thank you.
31 is the item, 30 and 31 are depicted here in defense 1309. Is that right?
Yes, the DQ alpha strips.
And in the upper left-hand corner, we see all the strips that were run that day.
Yes.
Now, you recall we discussed this, you and I, on cross-examination.
Yes.
And you would agree when I asked you those questions on cross-examination, the issues probably weren't so clear the way I did it that day with dots.
I thought it was clear.
Well, you thought it was clear. I apologize. But when Dr. Gerdes testified, he made points that were similar to precisely the points I was making with you when we visited this issue on cross-examination.
Objection, that's vague, no foundation.
It's argumentative, sustained.
Right. Now, you stated on direct examination one of the concerns that Dr. Gerdes expressed with respect to this 1.3 dot, correct?
Yes.
Now, wasn't one of the points that Dr. Gerdes made is that there was also evidence of the 1.3 dot appearing on the quality control sample 816 and the positive control in the same run.
Objection, that's beyond the scope.
Overruled.
Yes, he mentioned that in his testimony.
Right? And he took the position that scientifically, when your controls are showing 1.3s that shouldn't be there, it is improper to call a 1.3 that is also faint within a mixture. You remember he made that point. And your protocol, as we discussed when I cross-examined you, does say that if the quality control and the positive control fail or show unexpected results, that the procedure is to do it again.
That's what we would say, yes. In other words, if they show, I think the key word is whether or not they fail. In my opinion, they didn't fail.
I understand that, but you did not do this again.
That's correct.
However, and this is,
All right, Mr. Chair, just be careful because that easel
I
has
understand, I
a...
think I've got it.
Okay, it's got a limited capacity. All right,
1310.
1310, thank you.
However, on item 52 on board 1310, there was what you in your terminology call this 1.3 trace,
Objection,
correct?
it's beyond the scope, Your Honor, these are different samples.
Overruled.
Yes, it was called a C-minus / trace.
Right. And you also saw on one of the quality assurance sample in this run, what you called a trace of a 1.3?
Yes, I believe that's right, but I'd like to quickly check the note sheet for that day.
Would you accept my representation that this came from your note sheet? That's your
And that is my recollection.
And that on the positive control, it was a hint / trace?
Yes, in other words, there was more of a dot showing on this particular positive control than the previous one you showed me.
And that you decided, based on this data, to do it again.
That's correct.
And the 1.3 here, this is, item 52 is a Bundy blood drop.
Yes, it is.
And if that 1.3 were a real allele, then that would indicate that there was perhaps more than one contributor to the stain you had there.
Objection, 52 is beyond the scope of the record.
Overruled. But let's...
Yes, we're moving through it.
Yes.
Yes, you recall that? Okay. And you did it again.
Yes.
And in your notes, even though it's not really visible on this strip, it was recorded very faint trace.
Yes, I believe that's correct when I rehived it.
And you did, and the rehive indicates that the film was developed for 22 minutes.
I believe that's correct, yes.
And your protocol is to develop them between 20 and 30 minutes.
Yes.
And would you agree that the amount of time that you develop them may relate to the intensity of the 1.3 dot?
Well, beyond about 20 minutes, there's really very little difference in those. It's mainly what happens in the first 20 minutes that's the issue.
Well, you didn't indicate on the sheets how long the original run of item 52 was developed.
That's correct. I consulted with Renee Montgomery later on.
All right. Now, to finish this up, you recall that Dr. Gerdes criticized your results by saying that it was inconsistent to call this 1.3 not real, and without further testing, to call the 1.3 on sample 31 real.
I believe that was his testimony, yes.
Okay. So those are some of the concerns that Dr. Gerdes expressed with respect to full rendition of his concerns with respect to sample 31. Fair statement?
I think that covers about everything.
Okay. And just so we're all clear, with respect to the console of the Bronco and the samples that were collected on June 14th, the only evidence from DNA testing that you have with respect to the console is that 1.34 finding that you and Dr. Gerdes disagree about on item 31.
Yes.
Okay. Now, with respect to the results on 303, 304, and 305, you recall that Dr. Gerdes expressed the view that the integrity of the evidence had been compromised by the way in which the Bronco was handled between June 14th and August 26th. Do you recall that?
That misstates the testimony. That's argumentative. That's not what he said. It's beyond the scope of the direct examination.
I believe I saw that in his testimony, yes.
So you recall that with respect to his opinions about 303, 304, and 305, that was a concern of his.
I believe that was a concern, yes.
And do you have some familiarity with the way the Bronco was handled between June 14th and August 26th?
Objection, no foundation. Also speculation.
You can ask him if he took that into consideration.
Mr. Sims, from what you know about the way the chain of custody for the Bronco was handled between June 14th and August 26th, do you think it was handled appropriately in your forensic opinion?
Well, I don't know the whole history of how that Bronco was maintained. I don't know the whole history of that. I've heard that there were some...
Objection, that calls for hearsay.
Overruled.
Calls for speculation.
Overruled. It's an expert opinion, counsel.
Please continue.
Overruled.
I've heard that the defense has raised some issues with regard to that. I don't know the truth of the matter on all these issues, no.
Object, that's not responsive. Move to strike. There's no foundation.
Overruled.
Mr. Sims, you heard Dr. Gerdes testify about it.
I heard him express concerns. I don't know what his basis for those concerns were, other than the general term chain of evidence.
You have no knowledge with respect to whether or not this Bronco was secured for further biological analysis between August 26th and June 14th in a way that would preserve the integrity of the evidence. You have no knowledge of that?
Well, I know what I see in the newspaper, and I know, for example, that I think 2 weeks ago you called a witness that addressed some of those issues. But that's what my knowledge is.
And you have not familiarized yourself then at all with what the history was of how the Bronco was kept? Is that what you're telling us?
Sustain, rephrase the question.
Have you, let me try it this way. Mr. Sims, in your forensic opinion, based on your experience.
Is it necessary for him to be down there at this point? Simply because we ought to use the microphones when we have them.
Okay, if you could resume. I think it would save time if I keep the boards up for some reason.
All right, go ahead.
Mr. Sims, to try to cut to the heart of it quickly. Let me ask you to assume that between June 14th and August 26th, the Bronco automobile was put into a tow yard, that no records were kept as to who entered or left it between June 14th and August 26th, that unauthorized personnel were in and out of that Bronco automobile, that is, non-police personnel. They were in the seats, they were looking around the car. Would you consider that an appropriate way to preserve the integrity of biological evidence?
Well, I don't think that should be allowed. I don't think one should be allowed to come in and out of a car. I think that should be done by authorized people.
And that records should be kept as to who has access and doesn't have access to the vehicle if you're going to preserve blood evidence for future biological testing.
Well, when you put it in the context of records should be kept, I don't know. I mean, for example, there may be other tow yards that I've been involved with in forensic cases where perhaps just one person has the keys, so there's no record kept of all those things. But that should be controlled. Access should be controlled.
So your answer is yes.
Well, with what I added to that, yes.
Now, So basically, you have no basis for disagreeing with Dr. Gertie's judgment that the integrity of those samples, 303, 304, and 305, was compromised by the chain of custody procedures used in this case?
Objection vague as to what type of integrity was.
Sustain.
All right. You heard his testimony that he believed as a scientist that the chain of custody for these samples compromised the integrity of future analysis. You recall that?
Yes, I heard some of that.
And you're saying to us that you are really not familiar with the details of the chain of custody of the Bronco.
That's correct. I'm not familiar with those details.
And you have not endeavored to become more familiar with the exact details of how it was kept and who was in and out of the car.
That's correct.
And therefore, you wouldn't want to render an opinion on it because you don't have enough information.
Objection is vague as to opinion about what.
Well,
I think I did offer the opinion of what should be done with that kind of evidence as far as securing it, yes.
All right. So your general opinion that it wasn't handled properly, but you don't know the specific details of how bad it was.
Well,
Objection, that's argumentative.
it is.
I'll move on. Now, just so we're clear, what you have done since we last visited is that you combined the samples that were found on August 26th, 303, 304, and 305, and you put them together. Is that correct?
yes, I've put them together.
Now, all together, when you did the quantitations on all these stains combined, you came up with 72 nanograms of high molecular weight DNA.
Well, there was actually more than that, I believe, but some other tests were run in between. But it's about 72 nanograms.
About 72 nanograms.
Yes.
And looking at the results, you believe this to be a mixture.
Yes.
And the predominant contribution in the mixture is DNA that you say is consistent with Mr. Simpson.
Yes.
And that's something on the order of 3 to 1.
Yes, I would say it's somewhere in 3 to 1, maybe 2 to 1, but that's the right ballpark.
And therefore, the amount of DNA on the RFLP tests that is consistent with the profile of Mr. Goldman would be something on the order of 20 nanograms of DNA.
Somewhere in that area, yes. That's a reasonable approximation.
And that's why you had to put these probes, keep these probes cooking, so to speak, for 15 or 16 days to try to draw up the amount of DNA because there was comparatively a small amount there.
Yes, technically what's going on is that there's a low amount of DNA on that membrane, that southern blot that we made, which means that there's a low amount of radioactive probe that's binding, and so you have to let the film that's developing, you have to let that film go for a longer period of time. Usually we do these in a couple days, but for this type of sample, you have to let it go a week or longer to get those weak bands to show up.
And this is really at the, so 20 nanograms of DNA, that's really at the low end of your ability to detect, isn't it?
Yes, this is getting to the low end of the ability to detect.
Small amount.
Small amount.
Now, if we were to look at, give us some perspective. 1 drop of blood contains about 1,000 nanograms of high molecular weight DNA.
Yes, about 1,000 nanograms or 1 microgram, yes.
And in fact, you've seen estimates in the NRC reports and other places that some people put it as between 1 and 2,000.
Yes, it's in that area.
Now, if you, based on your quantitations, were to combine the amount of DNA that you got as a whole in 305, 304, 303, the August 26 collections, and for just the purpose of this hypothetical, let's also include the amount of DNA that came out of the swatches from 30 and 31. Are you with me?
Yes.
Would you not agree that combining all of those together, all that from the console together, the amount of DNA would not exceed 100 nanograms?
Well, it might slightly exceed that, but it's around that ballpark.
Around 100 nanograms.
Around 100 nanograms, yes.
So that's 1/10 of 1 drop of blood.
Well, you have to remember that with a drop of blood, for example, if you're testing liquid blood, that's not the same as extracting DNA out of a stain's worth of 1 drop of blood. So you're not quite talking apples. You're somewhat talking apples and oranges there, but in terms of the ballpark, you're talking about, maybe getting 3/4 of that DNA out. So, you can figure it from that.
So what you're basically saying, Tess, is that maybe if you're just dealing with a pristine drop of blood, you won't get 1,000 nanograms, you'll get 750. Is that what you just said in English?
Yes, that's what I just said.
Okay. And if we were to, and I mean no disrespect to that, just summarizing it. And so if you've got about 100 nanograms of DNA, and there's 750 nanograms in a drop of blood. Can you give me that fraction quickly? That would be, what, about a seventh?
Something like that.
Okay.
Something like that, yes.
So certainly just reasoning from the DNA alone, the amount of blood, just looking at the DNA in the console, as you said, is in the area of 100 nanograms of DNA.
Yes.
Objection, that assumes it was all collected.
Overruled.
Well,
Overruled.
That's object to
Overruled.
the...
Overruled.
Oh, okay.
may I answer?
Oh, you actually overruled that speaking
Calls for
objection?
speculation. It calls for speculation.
I overruled the objection.
Different one, right?
Ask your question.
Oh.
Next question.
Overruled the objection.
Can I finish my answer to that?
Oh, I'm
Your
sorry.
I thought
Never mind.
I thought you did.
I meant sustained, is what I meant.
That's what I thought you meant.
That's what I meant.
Okay. It's...
Here's the problem. The moment I start to think about something else, never mind.
I-
Proceed.
Thank you, Your Honor. Okay, now, you also were asked some questions on, which one? I'll start this way. Now, you don't know anything about the order in which blood was deposited on that console.
No, I don't know the order in which the blood was deposited.
Are you familiar with the testimony of Dr. Baden in this case, that Mr. Simpson told him that he had cut himself on the evening of
Kelly,
June
you walked into the same questions we heard
12th, I
for
believe,
weeks on
and
end
that
a little bit ago.
he had gone into the Bronco searching for his cellular phone.
That calls for hearsay, no foundation.
This was his testimony. And with a small cut on the side of his finger, and had bled within the Bronco. Are you familiar with that testimony?
Same objection. Calls for hearsay, no foundation.
Overruled.
Misstates the testimony.
Overruled.
No, I really wasn't interested in the doctor, is it Baden, how you say it, in his testimony? I don't recall that. I don't recall his testimony on that issue.
But, all right, just looking at it then from the point of view of forensic DNA expertise that you have, ask you to assume that there was an initial deposit of Mr. Simpson's blood on the Bronco from a small cut. And I ask you further to assume that at a later point in time, there was a second deposit. All right? Have that hypothetical?
Okay.
And if one assumes, for the sake of argument and for the sake of this hypothetical, that the bloodstains of 303, 304,
I hope that board
305,
doesn't
all
fall
right,
and crush that little
were
man.
all present also on June 14th, all right? So asking you to assume both of these, there's no question, just for the purpose of this hypothetical, that everything that was on in August 26th, right, that was found there, was also present on June 14th. Just for the purpose of this hypothetical. Are you with me?
Okay, on June 14th versus
Right.
August 26th. Okay, those are the two collection times.
Right?
Okay.
But if we assume that on August 26th, the finding, the stains there, 303, 304, 305, were also present on June 14th, but somehow they were missed, okay?
Okay.
Your conclusions with respect to mixtures are not inconsistent with two deposits at two separate times.
Objection. That's an improper hypothetical. Misstates the testimony. There's no foundation.
Overruled.
Candor.
Okay, I understand the hypothetical, but now give me the last phrase, please. The question.
In other words, your findings here of mixtures are not inconsistent with a contribution of Mr. Simpson's blood at one point in time, and then a subsequent contribution of blood from Mr. Goldman at a subsequent point in time.
That's correct.
And in fact, based on all the testing that you did, most of the blood, if we had withdrawn, most of the DNA that you extracted from that console is consistent with Mr. Simpson.
He is, in the samples that we looked at, he would be consistent with the main contributor of that DNA mix.
Something, when you combine 303, 304, and 305, something on the order of 3 to 1.
Yes, again, that's a reasonable figure. Something like 3 to 1, maybe 2 to 1.
Hey. We made it over halfway through. Oh, we almost made it to the end of part 1 for September 13th. September 13th only has 3 parts. And the third part is only 50 minutes. It's very short. So We'll get through part 2 tomorrow. Wait, yeah, we should get through finish this and get through part 2 tomorrow. So, that's Monday. So Tuesday, we'll get halfway through the first part of September 14th. Oh my gosh. All right, guys. Thank you so much for coming out. I appreciate it. We have a live stream tonight at 8 p.m. Otherwise, I hope you guys have a great, great day. All right? Thanks, guys. Bye.